My securities lawyer mind says be cautious. My crypto investor mind says, man, let's go to the moon. I'm ready. Let me get some Pepe and let's moon it out. I think some of the excitement is justified, and I think the odds very much tipped in favor of Coinbase after this.
Well, ladies and gentlemen, welcome to The Scoop. I'm your host, Frank Chaparro, editor-at-large at The Block, and we have JW back on the show, on the program today. You should know him because he's been on like twice in the past few weeks. So thanks again for taking the time. We've got a lot to catch up on. It was funny, like 2 or 3 days ago, in my newsletter, I wrote about how the market was in this like catatonic state of, it just seemed eerily quiet. And then, of course, yesterday we just completely rip across the board on multiple fronts after Judge Torres delivered that ruling on the Ripple SEC case, in which he basically, I think the bottom line, we can get into it, is the company selling of XRP on exchanges did not constitute the selling of securities. Now, I don't know if that necessarily means that XRP is a security or not in this judge's interpretation, but it definitely was a relative win for Team Ripple. Obviously, they can appeal. So that's kind of the bottom line there. How significant was this in your view, and do you think maybe the market is a bit too excited about what seems to be something that could still change in the future?
So I'm of two minds. My securities lawyer mind says be cautiously excited. My crypto investor mind says, man, let's go to the moon. I'm ready. Let me get some Pepe and let's moon it out. It's a partial win for Ripple. It's more of a win than I expected at the district court level. I had some issues with the SEC bringing the case, and I voiced those in some op-eds in 2020. So I've been vocal about that, but I thought the odds were more against Ripple than they ended up being. So I was surprised by how far this went. It does a few things. So the decision saying that the secondary sales in this particular instance are not sales of a security is a big deal. And the fact that the judge says, look, I'm not going to rule on otherwise XRP listed on exchanges because that issue is not before me right now. So that doesn't necessarily go our way, but it's at least an open question. The calculus for the SEC and Coinbase right now, this is one of those moments in litigation where something happens in litigation. And the judge looks at you the wrong way. A piece of evidence arises where your defendant is saying something that shouldn't be. Something happens, and you realize it's time to settle. It's time. This case is not going the way that we thought. It's time to settle. This is that moment for the SEC and SEC versus Coinbase. The SEC is at that moment right now. The law on how we could change substantially so that the SEC's flexibility going forward to use this tool and all sorts of other things could be significantly curtailed. And it also shows the most important thing about this case, whether it all survives at the Second Circuit or not, a year from now, a year and a half from now, I don't know. But the most important things it shows is that the judge is willing to learn about the technology. And if judges are willing to do that, that's a big, big deal. Let's start there before we get into the doctrine. If judges are willing to learn about the technology, that's a big deal. Historically, most of the how we test to determine something's an investment contract, therefore a security, therefore must register. Historically, what that was a rough cudgel the SEC used against scams and Ponzi schemes and flim-flam operations that had no economic substance behind them at all. And so they were kind of difficult to apply a strict test about, commercial transactions and what goes into them. It was hard to apply it because there was no there. And so what courts tended to do was say, you know what, you get the benefit of the doubt, SEC. We're just going to treat the Howey test as a flexible thing, and we'll just sort of put everything under that umbrella. This is a rare instance and a unique instance in which the SEC is using this cudgel against a totally new type of economic animal that's never been seen before. The fact that Judge Torres was willing to think deeply about the limited connection between Ripple and XRP, the blockchain, is a big deal, is a huge deal. Let's start there. The fact that she was willing to say, look, secondary purchases and these sort of programmatic sales were not sales of a security because the buyers there were not in contractual privity with Ripple. They were just buying XRP, and buying XRP doesn't necessarily translate to anything that furthers what Ripple does. She gets it. She gets blockchain. That's amazing in a way that the SEC has never admitted under the Gensler regime in anything they've filed or anything they've said. That's a big deal, and that's helpful. There are other smaller things that are helpful from this case. This case is great for airdrops, right? This case says airdrops are not sales of securities in the same way that the distributions of XRP to employees of Ripple are not sales of a security. That's great for airdrops. That's great for that model of issuing tokens and getting tokens out into the ecosystem if it holds up in the Second Circuit. So I'm excited, man. It doesn't mean we win, but I think some of the excitement is justified, and I think the odds very much tipped in favor of Coinbase after this.
Yeah, were you surprised though? Coinbase decided to relist the day of this decision. I mean,
yeah,
I guess their interpretation of that sort of ruling was maybe, okay, even if it's a security, the sort of secondary marketplaces that facilitate trading won't be implicated. It would sort of be concentrated around those folks who issued the token rather than the secondary counterparties that facilitated trading. So why not relist it? And also, it's kind of like a signaling thing as well, maybe to
that's the most important thing.
Yeah,
I think ultimately this was not a business decision. This was a litigation strategy decision. This was saying we're not scared, and we're ready to fight. I think it sends a strong signal to the SEC.
Your stock just, I mean, it's down a bit today after a major run up yesterday by like 20 some odd percent, more than 20%. I guess the sentiment there is that this could mean good news for Coinbase in its own case. Does it necessarily penetrate though at the, using my colleagues Colin Wilhelm's words, the armor of the SEC in other sort of circumstances?
Well, in one sense, the judge ruled against Ripple on the fair notice defense. Now, does that hurt Coinbase? Coinbase has a much stronger argument there because they went through the S1 process. And so that's a little bit of a different argument. But in that sense, that precedent probably weighs a little bit against them. Does the precedent that the programmatic sales in the secondary market, does that translate to Coinbase's listing process, which is not like the way that XRP got out into the secondary market, but should have some personal value? Yes, I think it does. I think it does. Whether that precedent helps them will depend upon particular communications Coinbase has made about particular listings that were referenced in the case. But I think they've been pretty careful about how they describe things in their documents. So I think they've got a good argument there. Ultimately, this changes the calculus for the SEC. In a normal commission, I think it would be settled, especially because Coinbase has already kind of put out the olive branch before the case even started with this request for rulemaking a year ago, where the Coinbase said, please regulate us.
So you're saying that you think this news or headline increases the chance of settlement for both Ripple and Coinbase?
I do, yes. Well, I think Ripple needs to fight. What they've lost today, they can't give up. They need to fight because it's pretty significant for those individual defendants. So I'm not sure that will settle. I think they probably need to fight. And they're willing to go all the way to SCOTUS, which is where I think they have a pretty good chance using the major questions doctrine. That's what we did. We did 2 sessions on that one. So we did almost a securities law and constitutional law class last time. Yeah, it's a shame crypto has to learn so much about the securities laws, but that's the situation we're in. So yeah, I think that helps Ripple a little bit, but it helps Coinbase a lot.
Well, we're having fun. We learned about bankruptcy proceedings. We're learning about major questions doctrine.
Yeah,
the industry is becoming more sophisticated.
Yeah, I think that's true.
We're the slings and arrows of everything that's happened.
Yeah.
Sorry, not to cut you off. Where were you going with that?
Oh, I was just going to say, but the settlement, the settlement is also much bigger than your typical settlement, because to really settle, the SEC has to commit to some adaptive rulemaking, exemptive relief guidance to make it possible to actually list this stuff. I mean, right now, the settlement can't just be, okay, we'll list everything and comply with the securities laws, because you can't. I mean, you can't like list Solana and comply with the S1 requirements, or on regular disclosures comply with 10K. I mean, there's 100 items that just don't apply. There's no board of directors of Solana. There's no CEO of Solana. So how would you have an audit committee of Solana? I mean, none of that stuff really applies. For a settlement to be possible, the SEC would have to come to the table and say, okay, we'll do some adaptive, exemptive relief and guidance and stuff like they've done loads of times before with asset-backed securities and limited partners, master limited partnerships, all the stuff we went over last time. So that would have to be part of it. But the calculus for the SEC has changed where they should come to the table and do that at this point.
I mean, again, so as Colin mentioned yesterday in a piece he wrote, they haven't lost a crypto enforcement case since 2017. So they have that relatively strong positioning, I guess, but they could sell like they did with EOS.
Yeah, that would be interesting. That's a different thing, because that was a case against an issuer, not an exchange. And the exchange has to figure out a path to list for settlement to really be possible. That's what makes it more complicated. The SEC has a good record so far. This is what changes their record. This is the one chink in the armor that could make the whole armor fall apart eventually. And you got to figure there are voices inside the SEC that are worried about the institutional interests of the agency that will stretch long past Gensler's tenure, and that say, look, we should settle in part because we don't want precedent that's going to hurt our ability to operate long after you're gone, Gary. He's probably more interested in the political stuff right now. This might also give him political cover to say, look, Liz Warren, I know you don't want me to do a special rule for crypto, but I have to because we lost. Maybe that helps him politically. I don't know.
What are the chances you think that this ruling gets overturned on appeal?
At the Second Circuit, I think the chances are it'll be modified in some way. It's not going to all survive exactly as it is, but that could go Ripple's way just as much as it could go SEC's way. We don't know. Some of the remaining aiding and abetting stuff could go Ripple's way, because it's hard to bring an aiding and abetting case in securities law. Maybe there could be more of a shot at the fair notice defense on appeal to Second Circuit. We'll see. And so it could go either way. I don't know.
Okay, fair enough.
But it'll have to be after trial and then a year for appeal. So it's like a year and a half away. And at that point, average tenure of an SEC chairman is 3 years. I think Gary will probably be gone before this thing gets resolved.
Much of it. So yeah, that's another interesting question. Like, how much of these actions would be happening if Chair Gensler was not heading the agency?
I think a new chairman, whether they're Democrat or Republican, would have an interest in coming in and settling out the cases and cleaning it up. I don't think they want this headache anymore. And I think an adaptive filing regime, it looks like Reg ABS, would be easy enough to do.
Yeah, but I guess on the Coinbase suit, they only really need to prove that one of them is a security, which makes it a bit of an easier task, I guess.
But if in that suit all the others are deemed to be not securities on a thorough analysis by the court, that helps all of crypto. That's not great for Coinbase, but that helps all of crypto. All of crypto wins.
Yeah,
huge.
That's a good point.
Yeah.
And then what happens after that? Like, I'm curious if, let's say that Matic, which just changed its name, I forget to what it changed its name to, but
yeah,
let's
don't
say
forget we got 4 years to move it over, so don't forget to do
that. Yeah. So let's say they say this one is a security. What's the recourse? I guess if the courts agree. Then it goes all the way to the Supreme Court. Supreme Court agrees that Matic is a security. Does Coinbase just delist it and pay a fine? What are the consequences, I guess, of this? I guess that's
worst case scenario is they could get shut down.
That would be pretty wild.
Let's hope not.
So what else? What else are you noticing, paying attention to right now?
Well, let's not forget the long-term stuff that we talked about. None of that was decided at this point, mostly because those arguments hadn't really been brought in Ripple. The major questions doctrine stuff really exploded with West Virginia versus EPA, where the SCOTUS signaled they were going to use this doctrine to go after agency abuse. That all happened pretty late. So that was December of last year. So that was too late to really put it in the Ripple filings in a big way. So it didn't come up yet. And I still think that's the strongest argument for Coinbase, Binance, and Ripple ultimately on appeal and to Supreme Court in the long term. None of that has come up yet. But I think that's the strongest thing as I understand it, as I've heard secondhand, that's something that the people on the 10th floor at the SEC are worried about. They care about that, the major questions doctrine. That's why I tell everybody in crypto, if you end up a defendant in a case, I want to see major questions doctrine in your filings. Just put it in there. Repeat it over and over and over. Just like in court, we're told as litigators, just object. No matter what. When in doubt, just objection. Even when you don't know what you're objecting to. Put MQD in those filings and everything. Make sure we're using it as much as possible.
Do you think this court decision could advance the legislative process?
A lot of people are saying that this sets up a legislative victory. Right now in the Senate, I don't see Sherrod Brown, the chairman of the banking committee, voting for anything that's been floated yet. He's not going to go for any of that. And now there's Chuck Schumer. So it's DOA for the short term. For the next year and a half, it's DOA. After that, depends on if the Senate flips. If it doesn't flip, if the Democrats still control one of the two chambers, then nothing's moving in that Congress either. Case doesn't matter for that.
We got to get Richie Torres in the Senate.
Yeah, there you go. Even then, it's still there are too many Democrats you have to get. So I mean, the Senate Banking Committee in Democrat hands is not going to pass anything over Liz Warren's objection, and the chairman, Sherrod Brown, is not going to even put anything on the agenda without Liz Warren's blessing. And I can tell you right now, there's not a crypto bill that Liz Warren would bless that any of us in crypto would want anything to do with. Better the uncertainty than whatever would come out of those negotiations.
Yeah, I think that some people are a bit too hopeful for that.
Yeah.
We were talking with Brian Quintez yesterday, and
I do like Brian, but I do believe he's very much too hopeful on that respect.
Yeah. Well, because it's funny. It's like a lot of the people on the Hill, like even, if you talk to like Kristen Smith, who we invited on to come out in August, it's like they want to believe that crypto's relatively bipartisan, but I mean, who is, I mean, obviously Jill Verret, working with Lummis and then Torres, but it definitely seems like the pro energy is very much strongly Republican and the anti-energy is very much strongly Democratic.
Well, I think Kristen has a sober view, and I'm not saying don't engage. She absolutely, it's her job to engage because one day something will pass. And right now right now the bill could get cemented to pass. I'm not saying it won't pass in the next 5 years. I'm just saying it won't pass in the next 2 years. So one day when it does pass, it probably won't change much from what's been considered and voted on. Once something's been voted on in the House floor a couple of times, you can't really amend it in the House anymore. So she and Jake absolutely should be engaging and designing that thing as best they can. I'm just saying, and I think they have a sober view of it too. Don't expect it to pass the next year or two. It's a long-term effort on the Hill.
Yeah, that stands to reason, and I feel like you'll probably see it become more. I just don't know what the shift was. Like obviously Trump was relatively anti-crypto before he did his NFT drop. Biden seemed a bit more reasonable, with his executive order, and now, they're calling out rich crypto traders for, in tweets and whatnot. So I don't know what was behind that shift.
FTX, man, the whole thing was FTX. All of it. All of the political shift was FTX. Sam Bankman-Fried was the largest individual donor to Biden. that influenced things. That absolutely influenced the White House's stance on the executive order. And then the blow up. The way Washington works is, and we learned this at Enron. The closer you are to a politician, if you have a scandal, the harder they're going to come back and light you on fire. That's what happened with Enron. Everybody in Enron, the Bush administration was like, "Hey, DOJ, just light them all on fire in the public square. It doesn't matter. The fact that we've taken $10 million from them means now you all need to light them on fire in the public square." So that's the way it works in Washington. You can get too close, and SBF definitely got too close.
And now Brian Armstrong's paying the price.
Yeah, well, that's a tough one.
If the XRP decision's upheld, does this pave the way to Bitcoin ETF being approved? Or
well, they're very different, but the odds there look really good so far after the DC Circuit opinion. I don't know that I would bet my Bitcoin on it. I wouldn't, but I like the odds. The odds are better than they were before the oral argument. A lot better. And look, if we were to play a game, let's find the 10 most ridiculous ETFs the SEC's ever approved. It would be a fun game to play one afternoon over beers. We would find some really crazy stuff, some stuff that has never made money for anyone ever in its history. We would find some ETFs like that. So how long can they hold out on this? After Canada's approved it, after Australia's approved it, they've approved Ethereum ETFs too. Eventually, we're gonna win this. And now that BlackRock's behind it, I mean, come on, man. Gary's a pretty politically attuned guy, and when BlackRock says they want it, he's not going to ignore that.
Yeah. So before the end of the year,
I'd say 40% chance.
Okay, that sounds about right. If you're right, we'll get you a beer.
Okay, good.
What else are you paying attention to?
In crypto, man, I'm a privacy guy. I'm wearing my Zcash T-shirt. For those of you that are listening, I always do it on the block, and in my DeFi education fund hat in solidarity with my DeFi guys.
We're swagged out today.
Yeah, you've got your AMP shirt on. I'm a big AMP fan, and Zcash and AMP have a good partnership too. Zuko was on a commercial with David Duchovny about Spedden. Anyway, paying attention to, there's obviously going to be a fight with the Reg ATS changes to define DEXs as exchanges. That's happening. DeFi Education Fund, Blockchain Association, all those guys are going to jump in that fight, which is important. I'm paying attention to privacy stuff right now. I'm seeing, and I want to be collaborative with the crypto community, and I don't want to burn senators who want to help us. But man, part 2 of Lummis Gillibrand. I don't know if you ever watched In Living Color. Hated it. Lummis Gillibrand part 2. Hated it. Big thumbs down from me, man. I can't support it. The privacy stuff is terrible. So there's a section in there that comes out of a bill that Chainalysis has been pushing on the Hill that would create a committee of a very unbalanced committee of all law enforcement, basically law enforcement plus, of course, Chainalysis gets on the committee as well. To look at crypto privacy. Eventually, I think do a report that's going to recommend outlawing mixers, outlawing privacy technology. Are they going to come after privacy coins, Zcash, Monero? I don't know, but I wouldn't put it past them. So that might lay the groundwork for that. And how can you be pro Bitcoin if you're supporting a section that's ultimately going to be used to come after Bitcoin Whirlpool, which is a totally legit mixer? I've never seen Whirlpool even associated with any post-hack stuff, though that wouldn't necessarily make it illegit either if there was some of that going on. It's non-custodial, obviously, so it doesn't have to register as a money transmitter. But if you ever tried Samurai, I don't know how you can be a Bitcoiner and not try to get some privacy by using Samurai Wallet, because that's the best Bitcoin privacy tech out there. But I'm worried it's going to try to get outlawed by some of the stuff that's starting the momentum in Lummis Gillibrand. I'm worried about that.
What did you make of the Arkham situation?
Hated it.
Another one.
I'm not against, not everybody's going to be as pro privacy as I am and my Zcash and Monero buddies are. In fact, most of the world seems to want to desperately give their information away to social media companies. That's fine. So if you want to participate in that, go ahead. I wouldn't outlaw it or prohibit it, but I'm never going to touch anything like that with a 10-foot pole. So.
Yeah, it was really absurd. Did you see that meme where they took like a picture of the Pentagon and like Arkham's logo and basically saying, "Oh, it all makes sense." They're complete
There
feds.
was some good privacy memes. Zuko Wilcox had one. I think it was good. Zcash demand generation app incoming.
Yeah. I asked him though when he came on the show. I was like, "So, are you a Fed?"
Right.
He was like, "No."
If he was a Fed, that's the best cover ever because the guy's been in privacy since he was like 15.
Yeah.
So.
All right, sir. Well, we'll leave it there.
Good to be here with you, Frank. Come back anytime, man. Thank you.
We'll be back for you again with another great guest. Have an awesome day.